Dear learners, in this lecture, we shall be looking at the law governing conversion of business organizations into limited liability partnership. So, during the course of our previous lectures, we have undertaken a detailed examination of what is an LLP, what are its legal framework, how does it compare with other business organizations. So the law also provides a provision for direct conversion of a partnership, private company, as well as a public company into an LLP, considering that it is a very distinct and flexible business organization. Now, what is the law and procedural requirements relating to its conversion? We shall be examining them under this lecture. So first, looking at the legal framework governing conversion of other business organizations into a limited liability partnership. So it is covered under Chapter 10 of the LLP Act, covering sections 55, 56 and 57. So section 55 relates to conversion of a regular partnership firm into an LLP. Section 56 of a private company into an LLP, and 57 unlisted public company into an LLP. Now, apart from these provisions, the detailed requirements are provided under the three schedules that are attached to the LLP Act. So for partnership, there is Schedule 2. For a private company, there is Schedule 3. And for unlisted public company, it is Schedule 4. So you can refer to those schedules for a detailed reading. Now first we shall be taking up conversion of a regular partnership firm into an LLP. So a partnership firm may convert into an LLP by complying with the requirements as to the conversion which are set out in Schedule 2 of the LLP Act. So Schedule 2 sets out the formalities, procedure as well as the eligibility criteria for conversion. There is Para 3 of the schedule which stipulates the eligibility for conversion. So it reads as, any partnership firm may apply to convert into an LLP in accordance with the schedule if and only if the partners of the LLP into which the partnership firm is being converted, they comprise all the partners of the firm and nobody else. So it is like there is a commonality of partners in both the business organizations. So the partners of the LLP, they are the same as partners of the other firm. So this implies that all partners of the LLP, they are common to the firm. So no person other than the existing partners of the firm may become a partner in the LLP. Now we shall be looking at the meaning of the word convert and what involves conversion in Schedule 2. So there we have Para 1 subclause B, which defines convert as, convert in relation to a firm converting into LLP means a transfer of property, assets, interests, rights, privileges, liabilities, obligations and undertaking of the firm to the LLP in accordance with this schedule. So it is the entire bundle of legal rights, obligations and interests which get transferred from a partnership firm to a LLP. So the process for this is that firstly there has to be a submission of statements along with the registrar of an LLP. Then the registrar has to register the documents. The documents will be the same as are required for registration of an LLP. Refer to our lecture on registration of LLP. Then after the legal compliances have been made, then there is an issuance of a certificate of registration by the registrar. Apart from that, there has to be an intimation or information of conversion to the Registrar of Partnership Firms under the Indian Partnership Act. After that, a business organization is registered as an LLP with the effect from the date of certificate of registration, which is issued by the Registrar of LLPs. So the essential requirements for this are, they are listed under para 4 of the schedule. So firstly, there has to be a payment of prescribed fees, which is prescribed by the central government, which has to be paid to the registrar for such conversion. Apart from that, there should be statement of all its partners, which detail the name and registration number of the partnership firm, the date on which such partnership firm was registered under the Indian Partnership Act 1932 or any other law. Then apart from that, the documents which are required for incorporation into an LLP, all these documentation and compliances have to be met as per section 11 of the LLP Act. Now the effect of such conversion is that the partnership firm is converted to LLP by the name which is specified in the certificate of registration. All the property, privileges, assets, undertakings which earlier vested with the partnership firm now vest in the LLP. Now partnership firm is deemed as dissolved, although there are separate ways in which a partnership firm is dissolved, but when it is converted into an LLP, it is automatically deemed as dissolved and it is removed from the records of the registrar of partnership firms if it was registered. So the effects, they are provided under para 7 of schedule 2. Then the next entity we are looking at is conversion of a private company into an LLP. So para 2 of schedule 3 to the LLP Act specifies the eligibility for conversion of private companies into LLPs. Now, what is a private company? Refer to our discussion on the various kinds of companies, in which we discussed a private company under the classification of number of members. So, a private company may be converted into an LLP by complying with the requirements of Schedule 3. So, a private company may apply to convert into an LLP in accordance with this schedule, if and only if there is no security interest in its assets subsisting or in force at the time of application. So the company should have no security interest in the assets of the LLP, like through mortgage or as a security, and the partners of the LLP to which the company converts, it should comprise all the shareholders of the company and no one else. So again, the partners of the LLP are same as shareholders of the company and nobody else. So upon such conversion, the company, its shareholders and LLP into which the company has converted, as well as the partners, they would be bound by the provision of the schedule and not by the provisions of the Companies Act. So convert in relation to a private company converting into an LLP, it means a transfer of all the property, assets, interests, rights, privileges, liabilities, obligations and the undertaking of the private company to LLP in accordance with this schedule. So there is a transfer of bundle of rights, obligations as well as assets from a private company into an LLP. Now this conversion is provided under para 1B of the schedule 3. Requirements which have to be met by the company are, firstly, it has to pay a prescribed fees to the registrar of LLP. Then it should contain a statement of all the shareholders of the company which should specify the name and registration number of the company, the date on which the company was incorporated under the Companies Act. Apart from that, the other requirements are that which have to be met relating to Section 11 of the LLP Act, which prescribes the procedure for registration of an LLP. So all the documents and compliances which are provided under Section 11 of the LLP Act. Now the stepwise procedure for this registration of conversion from a company into an LLP is: firstly, there is submission of documents with the registrar of LLP as provided under para 3 of the schedule. Then there is a registration of documents by the registrar who receives them, who then, after satisfying himself of all the compliances, issues the certificate of registration. Then there is an intimation of conversion of this company into an LLP to the registrar of companies, because he has to strike off the name of the company from that register. And the LLP is registered with effect from the date of issue of certificate of registration. Then the effects of conversion are that the company is converted to LLP by the name which is specified in the new certificate of registration of LLP. There is the transfer of all rights, interests and liabilities from the company to the LLP. The company is deemed to be dissolved and it has to be removed from the records of the registrar of companies. Now we will examine the conversion of a public company into an LLP. Now what is a public company? Refer to our earlier lecture on the kinds of companies, where we have classified company as private and public on the basis of number of members. So for conversion of a public company into an LLP, the mechanism is provided under Schedule 4 of the LLP Act. So para 3 prescribes the eligibility for conversion, and the eligibility is that the public company which wants to get converted, it should have no subsisting security interest in the assets of company, has no subsisting security interest in its assets, such as by way of mortgage or other security interests. And the LLP partners, they should consist only of the shareholders of the public company which wants to get converted into a public company. Then the registration for conversion, more or less it is the same as that of a private company, like submission of documents to the registrar of LLP, then registration of those documents, then after all compliances have been met, issuance of certificate of registration by the registrar of LLP. Then he has to intimate and inform about such conversion to the registrar of companies, who will strike off the name of the company from the register of companies. And the LLP is registered with effect from the date of issuance of certificate of registration as per para 6 of this schedule. The effects, they are the same as the effects of a private company. So you can refer to the effects which come into force from the date of registration. They are set out in para 6 of this schedule. So the public company is converted to an LLP by the name which is specified in the certificate of registration. All property, privileges, assets, undertaking of company, they now vest with the LLP. The company is deemed to be dissolved by such conversion and its name is struck off from the records of registrar of companies. With this, we come towards the closure of this short lecture, where we discussed 3 different business organizations, how they get converted into an LLP. So we looked at the legal framework, what are the essential requirements and what are the conditions upon which they can be converted into an LLP. So we had a look at partnership into an LLP, private company into an LLP, and unlisted public company into an LLP. So this provision for conversion is provided as LLP, a very modern and a distinct business model, may suit various business models. So if it is a earlier business which is registered under the partnership law or under the Companies Act, and now they find LLP very attractive. So this is like ease of legal and regulatory procedures so that they can be converted into an LLP which may suit them more as compared to their parent business organization. So with this, we end this lecture. Thank you very much.